Good afternoon, everyone. Thank you so much for joining us for today's webinar, which is another in our flood webinar series for 2022. This one is Floods and Insurance, How to Navigate Insurance Claims. My name's Carly Hanson. I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and emerging, and acknowledge that we're on stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland and potentially in northern New South Wales and other parts of Australia, I would also like to pay my respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who may be joining in on this session today. So today I'm really pleased to welcome Anne Hoffman from Herbert Smith Freehills, who's our one of our pro bono partners in this series, who will be talking to us today about floods and insurance. So specifically, the rain bomb over southeast Queensland left many properties flooded with water or otherwise damaged by the rain. It's resulted in significant damage to houses, businesses, cars and personal property, and it's been quite difficult for some individuals to navigate insurance policies and claims against insurers that may be available to them. So in today's webinar, Anne, who is a Senior Associate in the Insurance Disputes team at Herbert Smith Freehills, we'll take you through some of the key things to keep in mind when you're advising your clients on insurance claims and how to increase your clients' chances of a successful outcome, including things like which insurance is available, how should the client navigate a reluctant insurer, how can the client substantiate their claim, and other things. So I'll hand over to Anne in a moment to tell you a little bit more about herself and the session. But firstly, just some quick housekeeping. So today's webinar is being recorded and I'll have the recording available to download for you hopefully this afternoon. The PowerPoints are uploaded to the GoToWebinar control panel and you can download those just from the handout section there, and we'll email them out after the session alongside the recording. We obviously really encourage you to ask questions. So if you've seen any insurance issues coming through your community legal centres or other law firms, or if you're a volunteer lawyer that you're sort of doing some of this work, if you want to share some of the stories that you've seen or some of the tricky issues that you're getting, please do put them into the question box on the control panel and I'll read those questions out. Anne's also happy to take questions throughout the session. So if you do see something that triggers a question for you, please pop it into the question box. So without further ado, I might now hand over to Anne to start the presentation and I'll come back to you towards the end. Oh, and by the way, there are going to be a couple of polls that we'll share with you. So put your response in when they come up. That's just, check your listening and check your knowledge, and hopefully that's helpful to you as well. So thank you, Anne. Take it away.
Thank you, Carly. That's a very kind introduction, and welcome all to this webinar about how to navigate insurance claims in the context of the recent flood events. I'm going to try to make this presentation both methodical and practical. So I will be lecturing a bit, going through sort of the claim progression, both the substantive law and the process, the procedure. I know that on the website there's already a seminar up there about insurance in the context of the floods. That was put up, I think, in around about March, so quite soon after the events. And I've listened to it. I think it's a fantastic webinar as well, which talks about some of the more curly points that have actually already arisen. So I would also, in addition to this seminar, encourage everyone to look at that if there's still any questions outstanding, or if you need more on navigating the insurance claims. So what I want to do in this session, I've sort of split it into three parts, which is, first I want to talk about coverage more generally, which I think will take up most of, a lot of the time of this presentation, because that's really where the issues lie. Then I'll move on to some general considerations, practical tips, other issues that arise in the context of these insurance claims, and then lastly talk a little bit about the dispute resolution process. Before we go into the coverage issue, I just wanted to mention that what I think is a relatively positive development, which is that the Insurance Council of Australia has declared the floods a catastrophe. And by making this formal declaration of a catastrophe, that triggers certain responses by the Insurance Council and also certain obligations of the insurers. So, for example, the claims should be given priority by the insurers. The claims will be should be triaged by the insurers according to their urgency. We have Insurance Council representatives who are helping local agencies and services. We have insurers mobilising disaster response specialists, and task forces are being set up. So the insurers and the Insurance Council of Australia have obviously recognised this event as a major event that requires special treatment. And I know I've spoken recently to the General Counsel of the Insurance Council, and she said that generally insurers are being told, and insurers have told their claims assessors not to be too legalistic and be quite pragmatic about resolving these claims. So I'm hoping that that will actually bear fruit. On the website, I've just checked yesterday, it says that there's 168,000 claims being made and 159,000 still outstanding. So only 5% of them have been closed. That obviously shows that there's still a lot of work to be done. But I'm hoping that insurers will live up to this expectation of being quite pragmatic about it. So with that background, I was going to move on to the first discussion point that I wanted to raise, which is the coverage issue. So obviously, insurance is a contract, and a contract sets out the rights and obligations of either party. And in the context, and that's no different in the context of these flood events, and so the insurance policy will set out what is and what isn't covered. And it's important in that context to bear in mind the different perils that can occur, which is flood, we have hail, storm, rainwater, and all of those leading to property damage. In the 2011 floods, there was a lot of debate and a lot of disputes turned around the fact what is a flood as opposed to storm damage or rainwater damage. And insurance policies have different definitions of what flood is and what rainwater damage is, and so on and so forth. And following those disputes, it was recognised that that needs to change and that the consumer needs help. And so a uniform definition of flood was introduced. And so now we know officially what a flood is. And a flood is the covering of normally dry land by water that has escaped or been released from the normal confines of any lake or any river, creek, or other natural watercourse, whether or not altered or modified, or any reservoir, canal, or dam. So in other words, a flood is what comes up from the ground, whereas rainwater is what comes up from the top, comes down from the top. We'll go into more detail around the difficulties that still may cause. But just in general terms, the way that floods can be covered in insurance policies is either that it's a standard inclusion in the policy, or it could be a standard inclusion in the policy, but the customer can opt out of it. It's a not standard inclusion, but the customer can opt into it. That's the third type of insurance policy. Or it's not a standard inclusion at all in the policy. And what that means is that obviously very different policies will have very different approaches to floods. So some of them are covered, some of them aren't, as a matter of course, or they can be included if the customer so chooses. The result, or the why a customer might not, is obviously the fact that if you choose flood cover, your premium might go up, especially if you live in an area that is prone to floods. And so insurers are trying to give their customers that flexibility, but it also obviously now means that we cannot, there's not one standard answer as to whether floods are covered or not. So I've looked around and found some examples of policies and what you might see if a client comes with a policy. And so the first one says things we don't cover: loss or damage caused by, connected with, or arising from liability caused by, connected with, or arising from a bushfire, storm surge, flood, or tsunami in the first 72 hours of cover. So that only excludes floods for the first 72 hours of cover. So in effect, that means that floods are covered. So a bit of a roundabout way to show that there is flood cover. And the next one, which might be a bit small print, I hope you can read it, is the policy automatically provides cover for flood. However, your policy does not provide any cover for flood where your policy schedule shows that flood has been excluded. So that's an example of a policy where flood is by default included, but can be opted out of. The third example is perhaps the most interesting and comprehensive one, because it says what is covered is storm, cyclone, rainwater runoff, and what isn't covered is flood. At least that's the default position. But then you can see in the brackets on the right-hand side, the flood, the exclusion does not apply if you've selected optional cover for flood and it's shown on your policy schedule. So that's an example of a policy where floods are excluded, but you can opt into them, into flood cover. So those are the sort of the range of policies that are out there, and there's different variations of this, all sorts of different language that you can find, and it just reinforces the importance of knowing what the policy says and the policy determining whether cover for flood is provided. Now I've set in the next slide the first poll question, which is, what if you've got a policy which specifically excludes damage from flood? What would you advise a client to do in those circumstances? Make a claim anyway or not make a claim?
So that poll's just up on the screen for everyone who is watching, and I can see some results are coming in already. So just give you another 30 seconds or so to pop your answer in. So just another 10 seconds to get your response in there. Okay, great. I'll close that poll and share those results. So hopefully you can see those, Anne, as well.
Not just yet. I'm not sure what I need to do.
Oh, that's all right. Nothing. I think maybe, I'm not sure if it shows you as the presenter. So 95% of responses have said A, make a claim anyway, and 5% have said no, they're not going to make a claim.
Yeah, I would agree. I would agree with the 95% that says make a claim anyway. The the way in which exclusions work, so, sorry, taking a step back, generally these property damage policies cover property damage to property, that's it. And then you find these exclusions that say, well, for property damage caused by certain events, we don't cover. Generally, the burden of proof on proving those exclusions is on the insurer. So it will be up to the insurer to show that it's caused by flood. So there's no harm in making the claim anyway. It's the insurer who needs to work out whether the policy covers it or not. Secondly, you never know what else went on at the time the policy was entered into. There's certain obligations on insurers of making consumers aware of what is included and what isn't. So there might be a route into a claim there. And lastly, I think what is also really important is when you make the claim, it's not determinative, but the way I would phrase a claim is really just to say, I've had damage to my house, I've had damage to my washing machine or whatever's in the basement, and I'm making a claim for restoring that. You don't need to say what the cause of the damage was. You just need to say that you've had damage to the property. And then it'll be up to the insurers to work out, well, was the cause a cause that is excluded, such as flood, if that is the case. So I would agree with making those claims anyway. And I would even say make the claim even when you don't know what the policy says. If you know there is a policy, make the claim. Again, the insurer will have to work it out, whether there is a policy that covers it or not. You can also ask, of course, the insurer for a copy of the policy, and the insurer will have to provide a copy of the policy to you. And the sort of legal basis for asking for that is, not least under the privacy obligations, where you can ask for personal information that applies to you. I've got a question now. What are some of the examples which insurers have satisfied their burden of proof? We'll get to it in a little bit more detail in terms of how you can try to establish that it wasn't caused by flood, or that where the insurers try to show that it was caused by flood. So in short though, usually what the insurers bring along is a hydrologist report that says, the damage was caused by a flood, by a river overflowing or something like that. Great, so I'll move on to the next slide, which then goes into, I can't do it there, which then goes into a little bit more into the detail around flood versus, say, rain damage. So you've made your claim, you said there's property damage, you said you want reimbursement for it, but the insurers come back and denies the claim and says, no, this was caused by flood, you're not covered. And you say, well, but this wasn't caused by flood, this was caused by rain. The rain came down. And so if I go back to this, if I go back to this insurance policy, you can see here, storm and rainwater and runoff is covered. It's only the flood that isn't covered. So it'll become really important here when the insurer denies to be able to establish, is it a flood or is it rain damage? And as I just mentioned a moment ago, that's where the hydrologist reports come in. So the insurers will pay people to analyze where the water comes from, and they will put a report together, and usually for an area, not just for the one house, and they will say this is what caused the flood in this, or this is what caused the damage in this area. Now, in response, that's obviously, it's too expensive usually for individuals or for customers to also commission a hydrologist report, because they can be, I think $5,000 would be a cheap one. And so what is really important then in that context is to find evidence elsewhere. So talk to what did the customers see, observe themselves as it was raining? What did the neighbours see? Where, was it a downpipe that burst and that caused the flood, or I shouldn't refer to flood, I should say the water damage? What else happened in the area? Is there footage? Is there videos that were taken at the time? So it's really important at that point to try to collect as much evidence as you can to show that the hydrologist report was wrong, or find other other inaccuracies in the hydrologist report to show why it wouldn't apply. And so it's obviously time has passed a little bit already, but to the extent there's still an ability to collect evidence. I would urge all clients to do that and try to find whatever they can to rebut the conclusion of the hydrologist report. You might also ask, well, what happens? We all know, of course, that there was a lot of rain, and that meant that the river was overflowing, and that then caused the flood. So in sort of natural causation terms, you have rain, then you have flood, and then you have damage. So isn't everything caused, at least initially, by the rain? So this is then where we go into the concept of proximate cause in insurance law. And proximate cause is basically the sort of special causation principles that were developed for insurance claims. And the proximate cause of a damage is the dominant, effective, immediate or direct cause. And it doesn't have to be the last or the one immediately preceding the damage. It can be one, in this instance, that happened before the last event that happened. There may be more than one proximate cause. And courts, it's really difficult sometimes to ascertain the rationale, but courts generally try to apply a common sense approach. Would you say that it was the rain, or would you say that it was the river that caused the water damage? And so from these principles, sort of a rule of thumb would be to say, if the rainwater came before the floodwater, then the proximate cause is clearly the rain. If the rainwater came after the floodwater, then the proximate cause is the floodwater. Where they've mingled together, you may be able, on strict legal terms, it's probably deniable by the insurer, but you may be able to argue. And in particular, what I would try to argue is that parts of the damage were caused by the rain and parts of the damage then by the flood. If you can separate the two, if you can show what was caused by rain and what was caused by flood. This is also what the loss assessors, the claims assessors do when they come around and look at the properties. And the sad thing about, I've heard of a few stories that were quite sad in that context, is because people were loss assessors are trying to be very helpful, and they engage in conversation and want to learn what happened. But the issue is that a loss assessor is employed by the insurer. So they're not necessarily the customer's friend. And so some people have just been very trusting and have been talking to loss assessors and have been saying things that later on can be used against them. So in that context, I would just put out there a word of caution, not to, I think it's important to cooperate with the loss assessor, but just to bear in mind that they're not in your camp, as it were, when they come around to assess things. Then I mentioned already briefly that there might be also a legal way to address a denial of coverage, which is specifically, I think it was again introduced after the 2011 floods, that Section 37C of the Insurance Contract Act provides that before entering into a contract, the insurer must clearly inform the insured in writing whether the contract provides insurance cover in respect of loss or damage caused by or resulting from flood. So the intention there is that customers know very clearly whether they're covered by flood for flood damage or not, and so it's worth having a conversation with the client about, well, what did they tell you? Did they give you a sheet that shows this? Most insurers obviously try to comply with this requirement and be able to prove that, but it's still worth exploring. What did you know about your flood coverage when you entered into the insurance policy? I have then one last question on the coverage side of things, which is there will be other exclusions in the policy which are sometimes named in denials of coverage that they apply to so that the claim doesn't go through. The question is, can insurers deny coverage on the basis of subsidence or a lack of maintenance? Obviously two quite different concepts, and that's why I've put and or.
So you should see the poll up on the screen, and it does allow, because of the and or, for you to select one or other or both of those responses. So just pop your response in now, and I'll give you another 20 seconds to do that. So just 10 more seconds. Okay, great. I'll shut that poll down now. So the responses there, obviously there were some people that selected both answers, but unfortunately it doesn't look like that divvies those responses out. So we've got a tally that doesn't add up to 100%. So subsidence 67% and lack of maintenance 94%. So Anne, maybe you can talk to those responses and what you think the correct answer is.
Yeah, thank you. Yeah, so I think with subsidence, it's sort of the same issue around the proximate cause. So subsidence, obviously, if it's a subsidence unrelated to the rain and the water and the floods, then if that is the proximate cause of the damage, then sure, then that the part of the damage that was caused by subsidence is excluded. But at the same time, subsidence might also be the result of the water, the ground being so saturated that it gives way. So in that case, you would argue that the proximate cause is actually the storm, the rainwater, the runoff, and not the subsidence. So similar principle, similar discussion around the proximate cause would apply here. What is actually the dominant cause of the damage? Lack of maintenance is an interesting one. Similar, if you don't have the house well maintained, or everything is sort of not holding together all that well anymore, it's more a question around what can you get it to be restored to, and we'll come for the basis of settlement in a moment. The lack of maintenance itself is not a reason to exclude cover for flood, unless flood is generally excluded, is not in itself a reason to exclude the damage, because you still had whatever you had, and that was damaged by the rain. You are under an obligation after the event to mitigate whatever happened. And as I said, we'll get to it in a moment, it will be a question of what can you get it restored to, so the like-for-like restoration, but it's not in itself a reason to exclude cover altogether. So that's sort of what I wanted to cover in terms of coverage from the policies themselves, in terms of what are sort of the issues that arise in the insuring clause and whether the damage is covered. And I'll move now on because I can't see, is there more questions? Ah, yes, sorry. Isn't written policy informing in writing? Oh, sorry, I might have missed that. Isn't the written policy informing in writing? Is that maybe in the context of 37C, where it requires you to tell clearly about the floods? Yeah, there's a specific requirement. Thank you, Lyndall. There's a specific requirement that you have to make that very clear, and a lot of insurers, what they should be doing is not just have it in the policy itself, but they have it at the front of the policy as a special warning, so that they can show very clearly what that they've complied with that obligation. Because if it's buried somewhere in the policy, that may not be enough. Could I ask about the damage incurred in strata because the apartment was flooded, wasn't cleaned or repaired properly? Yeah. Etc. Affected apartment that wasn't otherwise flooded or affected. Yeah. So I'm not entirely sure. Is the question around, so tenancy agreements? I think there's separate training sessions on this, but my understanding is that in a tenancy agreement, obviously the tenant has a right against the landlord to restore it to a livable condition, and that that the tenant can ask the landlord to do that. Now, in a strata, if the property damage is because of a flood, even if it's mold or whatever it might be, that is property damage that can be covered by the policy. I'm not sure I'm answering the question. I mean, the other angle to this question is that the person, in case of owners not cleaning apartment affecting another owner. Yeah, I'm not sure that's so much an insurance question as opposed to whether you need to go after the neighbours then that didn't clean or dry the apartment properly, or the other apartment properly. Happy to discuss that further. I'm not sure I'm addressing the right question. We can chat about that maybe later. Very happy to. So then we'll move on to what, if you are successful after all this, what is sort of the result out of all of this? What can you get? The policy again will provide what the remedies are, or what you can get from the claim, and there's generally sort of 3 options out there: cash settlement, a like-for-like rebuild, or a sum insured. The cash settlement is where the insurer offers a sum of money that you can accept as part of the claim. And it's often sounds very attractive to clients because it's, often sounds like a big sum of money, and it often sounds like it would be good to have that in hand. But it's not always advisable to go for that option, and that is because it often sounds like a big sum of money, but especially now where tradespeople are in high demand, where building material is scarce, it can actually cost a lot more to rebuild than what you're being offered, and the clients are not necessarily aware of all those additional costs. There's also might be an angle with the mortgage company. So if you have a mortgage over the property, the mortgage might require you, and that's sort of the fine print of the mortgage. The mortgagor might require you to pay the cash money, settlement money, into the mortgagor's account, and then they release it as and when milestones are met for the repairs. So the one helpful thing around cash settlement I can mention is that because the Insurance Council has declared it a catastrophe, even if the claim in cash is settled within 1 month and the client's signed a release, they can still go back 12 months later, within 12 months, to say that they want to have another look, want the insurer to have another look at the policy and maybe increase the claim. So there's sort of, I'm not sure I would call 12 months a cooling off period, but there is another ability to maybe think about whether that was a smart choice or not. Probably the most useful thing that people get out of insurance claims then is the like-for-like restoration or the rebuilding, and that is where the insurer will actually take control over the rebuild. They often negotiate a scope of work with the insured, and the client can look at it and agree to the scope of work. On that, I would also mention that even if an initial scope of work was agreed and later it turns out that more work is required, or that different specifications are required, that scope of work can change. So you're not locked in from the very beginning. I would make that clear. I would say, yes, I'm accepting this on an interim basis and we'll see how we go. But you're not generally locked into the initial scope of work. And it is useful. I mean, this is where sometimes disputes arise as to what the standard of repair is, what the standard of rebuild is. But in my experience, the bigger issues are around the coverage issues that we discussed at the beginning. And once a claim is accepted, that can often, there's often a useful negotiation that happens, and that the repairs are done in the way that you want them, the clients want them. The important thing to note is obviously that you can't get it restored to a better state than it was before. If you didn't tell the insurer, well, if you want to improve and you want to get better materials in, then the insurer obviously doesn't have to pay for that. The sum insured are policies where it states in the policy schedule what the amount is that will be paid out in the event of a damage. That can be useful in some instances. Often though, the customers complain because they've recently upgraded their house and they've put an extension on or something, and then that increase in value is not recorded in the sum insured, and then they don't get that full amount back to rebuild the house. So it may lead to underinsurance, which is obviously unhealthy for the client. Just a quick word in relation to businesses. So there were of course a lot of businesses affected as well. Now, a house or a home property insurance does not generally provide for business interruption cover, because it's not expected that you run a business from home. So you would have to have a business property damage policy, and that then may have clauses in there that provide coverage for business interruption. So just a couple of practical points that I've seen come up, and I just wanted to mention them so that you're aware. Often a question is asked, is there a time limit on when to make the claim? There's, strictly speaking, no time limit, because this is an occurrence-based policy, which means it's triggered once the event happens, which is here once the flood happened. It's not a claims-based policy, which would be when is the claim made, and then it would be important to consider when to make the notification, but that's not the case here. So you can make it at any time. The difficulty, though, is if you leave too long, is that all that evidentiary helpful stuff about where did the water come from, what was damaged, all of that will be harder to prove. So I wouldn't leave it too long. Is there an obligation to wait with cleanup? So I personally haven't seen it, but there's some reports of insurers walking around saying you can't clean up until I've assessed the damage. And that's of course not right. You can, and in fact, you probably have a duty to mitigate and to clean up, because if you don't, the property damage might be even greater. So you can definitely tell clients that they can fix things up if they haven't already. But the important things are, as I've been saying a few times now, is that you need to take pictures first, or somehow a video, to have a really good record of what happened, what it looked like. Maybe even keep samples of the materials. You need to remove the water or mud damaged materials in case it's a health risk, but then make a list of the damaged items and what you've removed, and as detailed as it possibly can be, the brand, the model, the serial number, all of those things, so that you can later show what the value of an item might have been. If you have the space, you can advise clients to keep them somewhere and store the items. If your client wants to start rebuilding themselves, I would always suggest that they contact the insurer first before they do that, and work out with the insurer what their take on that would be, and whether they agree to that or whether they have another solution. And even if they say, no, you shouldn't do it, you can then still go ahead, but you can at least then show that you've given them notice. And yeah, so generally just if things can be salvaged or repaired, it's the duty of the client to mitigate the loss. So if it's cheaper to repair it than to buy a new one, then they're probably required to do that. On the last slide, I just wanted to briefly talk about the dispute resolution process, and I'm sure you're very familiar with IDRs and AFCA complaints. So in the first instance, I would suggest to go back to the insurer and invoke their IDR, their internal dispute resolution process. Sometimes clients are skeptical about that, but usually the IDR team is a completely separate team to the claims team, and they will have, the big insurers, they will have quite customer-friendly policies, and you know, with things like customer advocates and so on and so forth. So they will look at the claim fresh. It probably doesn't help much if it's just sort of a, I don't agree with the denial of coverage, but if any doubt can be raised in terms of the hydrologist report isn't quite right, you know, this is what I've observed, this is what my neighbours have observed, any tangible sort of doubts that can be raised there will be helpful in that process. I think there is a good chance that the decision will be different if you can substantiate why you think the insurer is wrong about declining the claim. I have a question. May I please clarify if the consumer has a home policy but also runs a business from at home, especially, does that mean the policy may will reject it because it's not a business policy? Well, it depends on, so if you have a home policy and you run a business from it, it depends on what you're asking for. So if it's a home policy and you're asking for the house to be restored, then that will go through, provided that all the other elements are met, that will go through. But what I meant is if you can't work because your house has fallen apart, and that would be a business interruption claim, i.e., you know, you're not making the same kind of money that you did before because you can't work, then that's usually not covered by these home property policies. They don't have a provision for business interruption because you're not generally expected to work from home. I hope that makes that clearer. Is there a time limit for the insurer to make good once the works have commenced? Not really. Not really. You can, of course, raise that as one of your complaints if you go to the IDR or if you go to AFCA, if they don't, if you're saying they're not doing it expeditiously enough. But I think it'll be hard to make out a claim like that at the moment, where just everyone is under pressure. Tradespeople aren't available as much as we would want. Material isn't as available as we would want. So it'll be hard to show that there was an unacceptable delay, but it's not impossible. And so once you've raised your complaint in the IDR process and it's still been knocked back, you can, of course, go to AFCA. It's got to be within 2 years of the IDR decision. I've dealt with a few AFCA claims, and you don't need to, as you know, you don't need legal representation, but a clear and concise and logical submission is always helpful, because I've seen a lot of AFCA complaints that are, because it's so easy to make an AFCA complaint, not a lot of work has been put into it. So I would suggest that the you know, more succinct, the clearer, the better it sets out all the facts that you're relying on, the more likely is you're going to get a favourable outcome. And then I've also seen a lot of AFCA complaints where then the complainant does not respond to requests from AFCA to progress the matter, to provide further evidence. You know, in the submission, the client might have said, you know, but this and this and this happened, and I've got this to prove it. And then AFCA says, well, show me the photos, and then nothing comes back from the client. So it's important that the client keeps monitoring whatever email address it is that they've given to AFCA to communicate with, so that it doesn't lapse, because AFCA can also, you know, discontinue claims if there's no response from the complainant. Often there's a jurisdictional and a substantive phase. So the insurer might initially say that that the claim is not, that AFCA isn't the right forum to bring the claim, but AFCA is quite strong in keeping matters. I think there's a limit of 1 million for AFCA claims, or around about that figure. So if it's higher than that, you might have to think about going elsewhere, going to courts. But that might not often be the case with the sort of claims we're dealing with here. So AFCA can also seek expert evidence, which is particularly relevant in the flood context. So they can either have the parties look at the parties' hydrologist report, which more likely than not will come from the insurer because of the costs involved. But AFCA can also appoint their own expert to look at the matter. I have not personally seen that, but it is a possibility. And then AFCA will make a decision, and as you know, AFCA will look mostly to, AFCA does not necessarily just make a legal decision. AFCA will also consider, was the customer treated fairly? And that will be relevant in the context of things like we discussed earlier. Was the customer made aware that floods are covered or not covered, and those sort of things. So anything that you can put forward in your client's favour, or the client can put forward in their favour, will be well regarded by them. So that's it takes me through to the end of the substantive and procedural points I wanted to make. In terms of summary, my key takeaway points would be: make the claim anyway, which I think all of you have said. Make the claim anyway, whether you have the policy or not. Get a copy of the policy, the insurer has to provide it to you, but make the claim anyway. Keep good records. Whatever you can do to keep records of what caused the damage and also the extent of the damage, that will be really useful. Be mindful of how you communicate with the loss assessors, just so that you don't inadvertently put something out there that you'd rather not let them know. And then if you don't get the result that you want, IDR in the first instance, and if necessary, AFCA. Those would be my 4 to 5 key takeaway points, if that's useful.
Wonderful. Thank you so much, Anne. There's one more question I'm not sure whether you saw there. You may have dealt with it, which was whether there's a time limit for the insurer to make good once the work's commenced. Did you respond to that one already?
Yeah, I tried to say that there isn't really. There's no prescribed time limit. Once the works commence, and as I said, if you wanted to make a submission that it's undue delay, to my mind, it would be difficult to make that claim because everyone is under so much pressure at the moment, and you can't say that you get priority over somebody else. That's my take on it. But if there's special circumstance, if you have really good evidence on that there's an unacceptable delay, why not? And also, I mean, those are the sort of things you can definitely make in the IDR process, points that you can make in the IDR and AFCA process, because it shows further impact and hardship that you've suffered.
And just turning to those questions from Fiona around the strata titled or body corporate apartment and what would be done there. Perhaps, Fiona, it would be good for you to tune into our next webinar, which is on body corporates. So that one will be happening, I believe it's next week. So you can register for that on our website and tune into that one, because there have been quite a few questions throughout this series on body corporates. That one's on the 3rd of May. which is next Tuesday. So I think since we've dealt with the questions throughout, we don't have any more questions coming through, which is wonderful. So on behalf of everyone who joined in today, thanks so much for attending, and thank you so much to our presenter Anne and to Herbert Smith Freehills for your time and expertise and sharing this really helpful information to our sector to help them to assist clients with their insurance claims. I'll just remind everyone that there will be a short quiz coming up to provide a bit of feedback on our session today. So please do fill that one in for us once I close the webinar down. As I mentioned earlier, I will send the recording and the PowerPoints in a PDF format out to everyone who registered following this presentation. So hopefully a bit later this afternoon, you'll have that in your inbox or first thing in the morning. And without further ado, I think I'll shut this webinar down, and we'll see you hopefully at next week's flood webinar, which will be the last flood webinar in our series on body corporates. So thanks again for joining us, and thank you so much to Anne for presenting today. Take care, everyone. See you later.
Thank you.